Welcome to the National American Indian Court Judges Association's Tribal Legal Advocacy Training webinar on the Indian Civil Rights Act for tribal criminal defenders and civil legal aid advocates. I'm Mary Rodriguez, a program attorney at NAICJA, and I'm happy you could join us today. About NAICJA, NAICJA, the National American Indian Court Judges Association, is a national nonprofit membership organization devoted to supporting and strengthening tribal justice systems through education, information sharing, and advocacy. NAICJA provides broad and comprehensive training and technical assistance to support tribal justice system capacity building and partners with national organizations to educate the broader legal community and public about tribal courts and judges, and builds relationships between tribal and state court judges. NAICJA is the Tribal Justice Training and Technical Assistance Provider under the Bureau of Justice Assistance, BJA, Tribal Civil and Criminal Legal Assistance, TCLA program, offering tribal and technical assistance, TTA, to TCLA grantees and sub-grantee legal aid organizations. NAICJA's TCLA program seeks to increase and improve access to legal assistance in Indian country by providing TTA for the development and enhancement of tribal justice systems. Further, TCLA will assist in strengthening the capacity and the quality of indigent criminal defense services and defense strategies for tribal justice systems. NAICJA is coordinating and implementing a multi-part training series, including webinars, interactive virtual training modules, and podcasts covering the basics of tribal court advocacy. The training series is tailored for entry-level legal services attorneys, either just starting out or those looking to bolster their tribal advocacy skills. At the end of this webinar, we will provide information on how to access the rest of the Tribal Court Advocacy Training Series. In developing the Tribal Legal Advocacy Series, we partnered with the Center of Indigenous Research and Justice, located in Olympia, Washington. Our presenter today is Ron Whitener, the president of CIRJ. CIRJ provides public defense services to tribes in Western Washington and training support to tribal public defenders nationwide. Before founding CIRJ, Ron previously was the founder and director of the Tribal Court Public Defense Clinic at the University of Washington Law School, and he continues to serve as an affiliate professor at UW. In 2011, Ron was named a champion of change by President Barack Obama for his work supporting and encouraging public defense in tribal courts. Ron was appointed the chief judge for the Chehalis tribes for 4 years and also for the Tulalip tribes for 6 years. Ron retired from the Tulalip bench in 2020 and currently consults with tribes across the U.S. on tribal justice system development through the Whitener Group, a consulting company Ron formed with his brother and niece in 2009. Ron is a member of the Squaxin Island Tribe of Washington State and continues to be active in his tribal community through commercial treaty fishing and serving on tribal committees and commissions. In today's webinar, the Indian Civil Rights Act for Tribal Criminal Defenders and Civil Legal Advocates, Ron will give an overview of what ICRA is, its history, and the case law that has shaped ICRA into what it is today. Thank you for joining us, Ron.
Thank you. Well, thank you very much for having me and asking me to do this. The Indian Civil Rights Act is something that criminal public defenders, civil legal aid attorneys, pretty much everybody that works in tribal courts needs to understand. And also so you don't step in it a little bit with the judge by coming in and arguing the United States Constitution in tribal court. And that's where I'm going to start, is with that issue. One of the most important things you need to realize in the area of civil rights is that outside of tribal courts, we look to the Bill of Rights of the United States Constitution. That's where we find our due process, our equal protection, our right, freedom of free speech, of assembly, of all the rights that we're used to as citizens of the United States. And we're used to that both applying to the federal government and then also to the state governments as well. So we have that Bill of Rights if we're being prosecuted by the state or being prosecuted by the United States. You don't have those rights in tribal court if you're a criminal defendant because the United States Constitution doesn't apply to tribal governments. And this is something that's been longstanding case law from the United States Supreme Court. Starting in Talton v. Mays in 1896, the Supreme Court made it clear that there's nothing in the United States Constitution that says it applies to tribal governments, and that because of that, federal courts generally don't have a federal question to be able to look at the validity of tribal laws. There's no tie to the federal system prior to the Indian Civil Rights Act, where the federal courts had any authority to look at tribal laws. Even today, that is still the case to a large degree, although the Indian Civil Rights Act did provide some federal involvement, and we're going to talk about that later. The other thing that's important to remember is that tribal sovereignty is inherently tribal sovereignty. It's not federal sovereignty that's given to the tribes. The tribes were not given sovereignty by the United States. They were given sovereignty by anybody. They had it. And the fact is that they've been independently sovereign since whenever sovereignty started for tribes. Sovereignty is an amorphous thing. What is a sovereign? A lot of it is, do other sovereigns recognize you as also being sovereign and treat with you as a sovereign? And in the United States, that was the case. The tribes were treated with by Great Britain first, and then later the United States as sovereigns entered into treaties with the tribes. And that's just something that has been the case, but it wasn't a gift. It was something that the tribes held. So when tribes prosecute someone, they're not prosecuting them under some sort of federal authority. They're prosecuting it under the inherent authority of the tribe that's existed for thousands of years. And because of that, another important thing to remember is that there's no double jeopardy between tribal court prosecutions and state or federal prosecutions. So for instance, if someone has, and this is a case that I defended at one point, there was a very large and fairly well organized methamphetamine operation on an Indian reservation that I was the public defender of. And that was a violation of tribal law. It was also a violation of state law, and it was a violation of federal law on each of those statutes. Now, all three of those sovereigns could have prosecuted the person that was running that house under each of those sovereignty pieces of the pie, or the cake. I always use the cake. So it's like a layer cake. As long as you're on the same layer, it's double jeopardy. So one layer is the United States federal government, another layer is the state governments, and then the third layer is the tribal governments. If prosecution occurs twice on the same layer, it's double jeopardy. If it occurs on different layers, there is no double jeopardy. So if a tribe prosecutes somebody, and whatever that act is also a violation of state law or federal law, it may be that that other jurisdiction also has the ability to prosecute that person for the same exact act. So with those sort of ground rules to keep in mind, let's talk about the Indian Civil Rights Act. So the Indian Civil Rights Act was passed in 1968. Up until that point, there was really nothing that sort of said what your rights were on the reservation, not just Indians, but also non-Indians. If you were being regulated on the reservation by the tribe, there wasn't anything like the Bill of Rights that regulated tribal governments. And some places it probably didn't need them. The tribe probably treated them pretty well. Other places, the tribal membership even was concerned about the liberties that their governments were taking over them. And they had an expectation that they should have rights similar to the Bill of Rights, protecting them against their own tribal government. So there were a lot of opinions about what that should be and how it should look, some ranging from that the tribes should have nothing that fetters how they interact with people on the reservations, over to people who wanted the full Bill of Rights applied to tribal governments. And the Indian Civil Rights Act was sort of a legislation that took it to the middle between those 2 points. The other issue that is there is that, you know, what if you do a federal statute, is the federal court going to be enforcing it? So who's going to be enforcing it? And we're going to talk about a little bit about that down the road as to who enforces the Indian Civil Rights Act. So let's talk about what it covers. So a lot of these are going to be really familiar, right? So free exercise of speech and religion, no unreasonable search and seizure, no double jeopardy, no ability to force someone to incriminate themselves, essentially the right to remain silent, no taking, so no taking of personal property without just compensation, right to a speedy trial, to be informed of charges against them, confrontation of witnesses against them, the ability to get subpoenas for witnesses to testify for the defendant at no cost to the defendant, and an assistance of an attorney at their own expense. So that is a big difference between the Bill of Rights and the Indian Civil Rights Act, is Case law over time has created a right to an attorney in the state and federal systems for most crimes that are charged under the Indian Civil Rights Act. And we'll talk a little bit about when there is a triggering of a right to attorney, but essentially any crime that has a penalty of a year or less or a $5,000 fine or less, no attorney has to be provided to a defendant, even if they're indigent. All other things that are covered, no excessive bail, no excessive fines, cruel and unusual punishment is not allowed, limits on who can be prosecuted. There's limits on the very limited, we'll talk about the very limited way that a non-Indian can be prosecuted, limits on imprisonment. So up to a year in jail and a $5,000 fine if the tribe doesn't meet certain criteria. If it does meet certain criteria, then it can go up to 3 years per charge and a $15,000 fine per charge, and the ability to stack or serve consecutive sentences up to 9 years in jail. And we'll talk about those requirements that the Indian Civil Rights Act has for being able to do what we call enhanced sentencing from the Tribal Law and Order Act. You have the right of equal protection under the law. There's no deprivation of liberty or property without due process. Freedom of bills of attainder, which we don't really see much anymore, or ex post facto laws. Ex post facto laws are laws that are passed that make something illegal. You can't then go and punish someone who committed an act that was not illegal prior to the passage of the act making it illegal. That's an ex post facto law, so we can't do that. And then a jury of at least 6 in all criminal trials. Just real quickly, some of the differences between the Indian Civil Rights Act and the Constitution. One is the separation of church and state. The Indian Civil Rights Act does not prohibit tribal governments from establishing and supporting religion. Some tribal governments are very much part of the religion of the tribe, and it's incorporated throughout. And the Indian Civil Rights Act doesn't bar that. There's no juries required in any civil cases. So regardless of what the damages are or anything, that can be front of just a judge. You can provide a jury if you want. We do see situations where some tribes have code that allow juries for certain civil matters. It's pretty rare though for tribes to do that. Then again, no right to a publicly appointed attorney in criminal cases with less than a risk of 1 year of imprisonment. No ability to sue the federal government in federal court to enforce the Indian Civil Rights Act, and we'll talk a little bit about that. No waiver of sovereign immunity of tribes to sue in federal court or to sue in tribal courts to enforce ICRA. So ICRA didn't waive the sovereign immunity of tribes. There's no explicit waiver in it that allows someone who believes that the tribal government is violating ICRA. You can't just sue them in tribal court. You can't sue them in federal court. So you're kind of left with whatever system the tribe has for enforcing the Indian Civil Rights Act. And we'll talk a little bit more about that. So we had immediately after 1968, though, there's nothing in ICRA that says specifically that there's no federal court cannot enforce ICRA. It doesn't say that. It's just silent. And so coming out of the blocks, excuse me, we had the federal courts looking at ICRA and finding a federal question under 2 different headings, 28 USC 1331A and 1343-4, sort of general federal question and then civil rights jurisdiction. So they were accepting cases where someone believed that the tribe had violated the Indian Civil Rights Act. They then would file in a district court, a federal district court, a challenge to whatever that tribal action was, using the Indian Civil Rights Act. And so we saw the federal courts looking at a bunch of things that were pretty internal to the tribe, things related to election disputes, things related to enrollment disputes, voting rights litigation, apportionment, criminal rights. So we see a lot of these issues being addressed right out of the blocks after ICRA was passed. And then it finally got up to the United States Supreme Court in Santa Clara Pueblo v. Martinez. And so in this case, the Pueblo had very strict, very traditional rules on who could be members of the tribe. And it was very much if you looked at it through the lens of the Bill of Rights and through the case law of the Bill of Rights, it would have been an obvious violation of equal protection. Because what it said was that if a child was born of a male citizen of the Pueblo, then the child could be enrolled. But if a female member of the Pueblo was impregnated by a non-member of Santa Clara Pueblo, then that child would not be able to be enrolled. So it was clearly a discrimination toward male of the tribe and against females for essentially the same thing. It went again through the federal court, the 10th Circuit. It went up to the 10th Circuit, who found that the Pueblo's tradition violated the equal protection provisions of the Indian Civil Rights Act. And then it went up to the Supreme Court. And the Supreme Court looked at it and said, well, look, the Indian Civil Rights Act didn't waive tribal sovereign immunity. It didn't say that tribes could be sued under it. It had this list of things that bound the tribes, but it didn't specifically say that you could sue them in federal court. The other thing was they noted that Congress didn't completely throw out federal court. It created one way to be able to try to enforce it, the Indian Civil Rights Act, and that was only through habeas corpus. And habeas corpus is a much narrower door to get through than general federal question. So it has to be a certain type of case before Congress will look at it through habeas corpus. Usually cases involving false imprisonment or illegal detention is the general lens of what you see through habeas corpus. So what the court said that the purpose of ICRA was that it has competing purposes. It's both to strengthen the position of individuals as opposed to tribal authority, but it's also promoting the federal policy of furthering tribal self-governance. So it has these two conflicting purposes, or at least competing, right? One, to try to provide some protections for individuals who are subject to tribal authority, but at the same time, trying to further tribal self-government and not having federal authority coming in and trampling that, which is really a hard line to walk. And ICRA tries to walk it, and I don't know how well it walks it. Sometimes it's fine, sometimes it's not. But what it boils down to is that federal forums are the primary place to enforce the Indian Civil Rights Act. It's an argument that you have to make in tribal court. And if the court goes with it, great. And I think over time, what we see is more and more tribal courts are comfortable with these Indian Civil Rights Act provisions. And if there's a criminal prosecution, if there's things like child welfare cases where children are removed, the courts are very good. The tribal courts are very good at applying the Indian Civil Rights Act and providing those protections. The one area where it's difficult is when you have the tribal council doing something that a person may consider to be a violation of the Indian Civil Rights Act. If the tribal council hasn't waived immunity to allow it to be sued or the tribe to be sued to try to get some sort of injunctive relief, then you're kind of stuck. You have this Indian Civil Rights Act right of protection against, say, a violation of your due process, but you don't have an avenue to get to the tribal council to stop them doing whatever it is they're doing. So you only can really look at federal habeas corpus jurisdiction. And that's, like I said, a real narrow gate to get through. So some of the things that we have with habeas standards, we do see it used a little wider in the Indian Civil Rights Act setting than you would see in other settings. They've used it in some things related to, and I'll go through some of those cases that courts have used the Indian Civil Rights Act a little more expansively, the habeas jurisdiction. But a lot of the things that you're going to see Indian Civil Rights Act being involved in is Indian status, this right to counsel, governing search and seizure by tribes, governing banishment of tribes of individuals they want to banish from their reservations. And then there'll be future trainings on Tribal Law and Order Act and Enhanced Sentencing and Violence Against Women Act reauthorization. But it also, the Indian Civil Rights Act now has provisions for tribes to be able to incarcerate up to 3 years, and also to be able to prosecute non-Indians who commit domestic violence against Indians on a reservation. So looking at just some of the habeas corpus standards. So habeas corpus, as we can see in this Alaska case from 2017, where the court sort of discusses ICRA habeas jurisdiction, and they note that usually habeas corpus is involving the physical custody of a person, that somebody's essentially in jail and you're trying to get them out of jail. But that ICRA does have a little more expansive purview than actual physical custody. Another thing, though, is important to remember, though, is that often the federal courts will require exhaustion of tribal remedies before you ask for habeas. So essentially, if the tribe is doing something and you disagree with it, and you have options to be able to try to appeal it, you need to go through those generally before you move to habeas. There may be exceptional circumstances, extreme situations of detention, maybe cruel and unusual punishment or something like that, that you would be able to get a quick reaction from the federal court. But generally, they're going to require you to exhaust your remedies, including habeas. So if the tribe has a habeas process, the federal court will require that you exhaust that habeas process in the tribal court before you go to federal court, which I think is a good thing for tribes to do. So if you're a tribe listening to this, I think it's important to have a tribal habeas process so that you can try to get this dealt with within your own system, either directly to your tribal court of appeals or maybe through the trial court and then up to the court of appeals, something that allows the tribe to have a opportunity to cure something before it gets into a federal habeas case. And then just one other little note from this Alvarez v. Lopez case from 2016, that if the tribe doesn't come in and argue exhaustion, then the federal court can waive it. So then allow the federal court to hear it. So that's something, you want to, if the tribe does get a federal challenge, if it doesn't come in and raise exhaustion, then the federal court could decide to proceed, even if things haven't been exhausted. So right to counsel, just some of the issues related for right to counsel. We have this recent case, United States v. Bryant. It still doesn't have a US site for some reason, even though it's been 5 years since it came out. But this was an issue of actually looking at the federal habitual domestic violence offender laws. So under federal law, if there's a federal statute that allows the United States to prosecute somebody who commits domestic violence if there's a certain number of domestic violence convictions that occurred on federal enclaves. So like national parks or national forests or military reservations, but included in that is also Indian reservations. So what you essentially have is that you have, if a tribe or tribes have prosecuted somebody for domestic violence a certain number of times, I don't quote me, I think it's 3, I should have had this in my notes. I can't remember exactly how many convictions you have to have, but it will then trigger this federal habitual domestic violence offender statute and they can be prosecuted on it. Now, one of the things that was a challenge to that is in US v. Bryant, what the issue was is that you had cases where people were not provided attorneys at the tribe. So you had domestic violence cases with a maximum penalty of a year or less and a $5,000 fine or less. And so they didn't have a right under the Indian Civil Rights Act to appointment of attorney. They didn't get appointed an attorney. They got convicted or they pled guilty, but which resulted in a conviction going in for domestic violence. And then later, the federal court used those uncounseled convictions to find that it still met the requirements for the federal habitual domestic violence offender. And it was a bit of a tussle and there was arguments back and forth between justices. But essentially what the court came down to is that it depends on the jurisdiction from where the conviction comes. If it comes from a jurisdiction that there isn't a constitutional or statutory right for public appointment of counsel, then using those convictions is fine. This case really isn't about inherent tribal sovereignty. One of the things that I got into some arguments with people when this came out is they were all very excited about it, but I didn't really see, it didn't really say anything about tribal sovereignty. It was whether or not the United States federal court was going to use these convictions. And so, basically the way they wrote it, it could be if it came from another country, that didn't provide a right to an attorney, then they could use that too. So it was really a federal situation. It didn't really strengthen or weaken or whatever tribal sovereignty. It just sort of said that what tribes do is fine as long as there's not a constitutional or statutory requirement for an attorney. Other cases regarding right to counsel. Again, we've got a few other cases like a person, excuse me, it's illegal for a person convicted of a misdemeanor crime of DV to possess firearms in or affecting interstate commerce. One of the things is this unlike the habitual domestic violence statute, this required that the person had been represented by counsel or they knowingly waived it in their previous convictions. But what the court said in the Eighth Circuit was that Long had been represented by a lay advocate, so not an attorney, and they found that was sufficient to allow their conviction as a predicate offense. Use of a tribal conviction and Bundy, where the judge did not make a knowing and voluntary colloquy with the defendant, could not be used as a federal predicate crime. So in this case, they weren't looking at specifically the right to counsel, but it shows that the tribal conviction still has to follow some sort of due process. So in this case, in Bundy, the defendant pled guilty. The court did not go through the usual colloquy with them on whether or not their decision to change their plea was knowing and voluntary, an intelligent waiver of all of the rights that you give up in making a plea. And because the court didn't do that, then that crime could not be used as a federal predicate. So the court still has things it has to do, even if you don't have the right to an attorney. Some other cases regarding Indian status. Federal prosecution of Indians under the Major Crimes Act was not based on impermissible racial classification. So that was an attack on US v. Antelope. Membership in a non-federally recognized tribe is not sufficient to meet Indian status requirements under the Major Crimes Act. So again, this was a case where the tribe was trying to prosecute, well, actually the federal government was trying to prosecute a member of a non-federally recognized tribe under the Major Crimes Act. And what we see here in this case, LaPierre v. McCormick, is that you need to be a member of a federally recognized tribe in order to meet this Indian status requirement, or you have to be, if you look at the cases for, and we'll talk about Indian status for being Indian who's not enrolled, it still has to be in a federally recognized tribe to meet the requirements of the Major Crimes Act. A non-Indian conviction for assaulting an unenrolled but quarter native daughter was upheld under the Major Crimes Act. So Indian status, it created a two-prong test for determining if somebody's Indian. It doesn't have to be membership. There needs to be Indian blood and some tribal recognition of that Indian status. So if you don't have that and they're non-native, that could trigger habeas. Under United States v. Bruce, an Indian parent, grandparent, or grandparents was sufficient to determine the Indian prong for someone who's not enrolled but still Indian. And then the fact that they received tribal benefits was sufficient for that tribal recognition prong. So we see a little bit further refining of that issue of who is an Indian. Ramirez sort of continued the discussion. And then Eagle in 2010, that when the federal government is prosecuting under the Major Crimes Act, it must prove Indian status as an essential element to prove beyond a reasonable doubt, and that the Indian Civil Rights Act does not require tribes to prove as an essential element, and defendants must raise the defense in a timely manner. So under ICRA, so what we have is this discussion of who is an Indian, which as a defender is relevant to who's being prosecuted. So are you an Indian or not is something that we as defenders need to think, because it does occasionally come up. It's pretty rare. Usually the tribes that I've been a public defender at or been a judge at, they do a good job of making sure that the person in front of us is an Indian. Now, it happened early on in my career as a public defender. There was someone who everybody thought was Indian, who was Indian, could be enrolled at the tribe, but had never enrolled. But everybody thought he was enrolled, so they prosecuted him. I had another situation where another tribe thought somebody was an Indian, he was a descendant, he was always at the reservation, and they had prosecuted him over and over and over, and he had never raised the issue that he wasn't Native. And then eventually he raised it when he got charged with something a little more serious, and he was actually looking at some jail time. Then all of a sudden he pointed out that he wasn't actually enrolled. But these are cases that sort of show that you don't have to be enrolled for the tribe to have jurisdiction over you, that this case law creates a balancing test. So you want to take a look at that to make sure if they do charge someone who you don't think meets these, then this is definitely a habeas issue. And then the Las Vegas one, just last one in this area, that the tribe can't rely on tribal recognition prong of Indian status test when they disenrolled somebody or refused to enroll somebody. So you can't say you recognize them as Indian if you're the tribe where you've already disenrolled them, or refuse to enroll them if they've tried to get enrollment. That sort of ends this tribal recognition prong of the Indian status test. So some due process habeas issues in Randall v. Yakima Tribal Court. We can see some of the expansion of habeas. In Randall, the tribal court dismissed an appeal as untimely when the tribal court failed to rule on a motion to waive an appeal fee. So essentially the person was convicted in the tribal court. They filed an appeal. There was a fee that the tribe had. They made a motion to waive the appeal fee because they said they were indigent. The tribal court never ruled on that motion. And then when the time limit on an appeal ran, they then said the appeal was untimely. The federal court took that case under habeas, saying that no, that's too much of a violation of due process. We're going to review that on habeas. In Alvarez, habeas was available where the tribal form that was used informed the defendant of their right to jury trial, but gave no explanation on how to invoke that right, no counsel to explain the rights that they had, no effort by the tribe or the tribal court to ensure the defendant knew of the right, and the defendant had a 7th grade education. All of those factors joined into where the federal court felt that they should step in under due process of Indian Civil Rights Act, and they granted habeas. They've used the federal courts have used the Indian Civil Rights Act habeas provisions a little bit in child custody. So it's sort of gone both ways. This is not an area where the court has done it a lot. For instance, in Weatherwax, the Indian Civil Rights Act habeas challenge was unavailable to challenge the validity of a tribal court child custody decree. But in Dement, habeas was available from the tribal court order that removed custody from the non-Indian father in contradiction to a valid state court order granting custody to the Indian father. Under Azure Loan Fight in 2004, though, we see the court saying habeas is generally not available to challenge proprietary wisdom of tribal court decisions in child custody. So the courts are pretty loath to jump into sort of just general child custody issues. Now, habeas is provided not just in tribal court, but elsewhere, so that if someone takes a child and is keeping a child that doesn't have a custodial right, habeas is often used to be able to get that child back. But we can see in terms of just child custody fights, federal courts aren't super anxious to jump in on habeas from tribal court decisions. Banishment, the courts were a little more willing to look at it if the tribe was going to banish somebody or exclude somebody. So in Poudre in '96, the habeas was available for petitioners who'd been excluded from reservations without any notice or opportunity to be heard or having any appeal rights. Also in Sweets v. Hintzman in 2008, habeas was available for a person banished by tribal council, but there were no tribal remedies to exhaust. There was no way for them to have anything reviewed, no appellate review over banishment. And so the Western District of Washington granted habeas in that situation. But then in Tavares in 2017, the court found that habeas is not available as a remedy for economic restraints, so things related to per caps. And temporary exclusions, not the permanent ones like we saw in Sweet, but a temporary exclusion was not tantamount to detention for purposes of habeas. So the last area that we'll sort of discuss where there's things I think that are relevant for criminal and civil legal aid attorneys is in the area of search and seizure. So under United States v. Nelis in 2016, the court found that tribal hotel staff are not an arm of the tribal power of a self-government to establish an exclusionary rule in federal court, even if they were no expectation of privacy in a hotel room after checkout. Essentially, as you could probably tell from the description, somebody stayed at the tribe's hotel. They left after checkout and left illegal substances in the room. Tribal hotel staff found it, and it ended up turning into a search and seizure fight. And the tribal hotel staff, even though the tribal hotel was owned wholly by the tribal government, it's not an arm of the tribal power of self-government. Plus, once you check out, you don't really have an expectation of privacy after that point. You should check under the bed. Under United States v. Cooley in 2019, we had and I got to update this. Oh my gosh, shoot. We've got the Supreme Court decision now. So United States v. Cooley, we had the exclusionary rule applies to evidence obtained in violation of the Indian Civil Rights Act. So in that case, tribal officers can detain a non-Indian for purposes of determining an Indian status and can hold until custody by state or federal officers. But what happened in Cooley was the tribal officer detained the non-Indian, saw in plain view drugs, searched the car, and then turned the non-Indian over to BIA officers. What the Ninth Circuit ruled was that the tribal officers may not search non-Indians who they don't have jurisdiction over. So you can hold them, but the tribal officers can't sue them. This was appealed to the United States Supreme Court, and we received a decision just a couple of months ago. And the United States Supreme Court unanimously overturned the Ninth Circuit in Cooley. So essentially what they said was, no, you have the ability, and they analyzed it under what we call the Montana rule, which is the rule that governs when tribes can regulate the activity of non-Indians on the reservation. And what they said was this falls under the health, safety, and welfare exception to that the tribal officer has the ability to hold them, has the ability to search for protection of the officer and for protection of the tribe, and then can turn that all over to the government that has the prosecuting authority. And the court made a big deal about the fact, the Supreme Court made a big deal about the fact was that the person wasn't going to be prosecuted by the tribe. It was going to be prosecuted by this other jurisdiction. All the tribe was doing was doing the seizure of the person and then the search of the vehicle, which conformed to federal search and seizure law. So in that case, it didn't matter if the person was non-Indian or not. The tribe had the ability for health, safety, and welfare to conduct that search. So that is now the rule under the United States Supreme Court decision in Cooley. So that is the overview of the Indian Civil Rights Act. Like I said, there are other areas that we're going to be talking about later related to enhanced sentencing under the Tribal Law and Order Act, and an overview of the Tribal Law and Order Act. That'll be in a different webinar. And then also a discussion of the Violence Against Women Act and the tribal ability to prosecute non-Indians who commit domestic violence on the reservation against Indian women, and the rules in the Indian Civil Rights Act. But that is for another webinar. Are there any questions?
Yes, Ron, we have a couple questions. Actually, we have three. The first one would be, what are the requirements for a habeas petition?
Well, it's a little amorphous. I mean, your safest one is if you've got somebody who's incarcerated and you don't believe that they should have been incarcerated. It could be I sort of highlighted some of them. So if you've got somebody who's a descendant of a tribe, but isn't enrolled, that's a gray area. Especially if you're dealing with somebody who I think is a descendant of a tribe that's different than the tribe prosecuting them. So I think that's one of the things you want to look for in terms of, so you've got somebody who's incarcerated. If you think that bail is excessive, You know, if you've got somebody who did a minor crime and the tribal court applied a $10,000 cash only bail, you know, at some point that's going to trigger that habeas if they're in detention. Your best bet is, you know, if habeas is going to be triggered, it's probably going to be triggered by either a criminal case where someone's in jail, or a banishment case where someone's been banished without any ability to defend or answer for it, for a permanent ban, not a temporary ban, because they can do a temporary ban until they actually hold the hearing. That's not habeasable. But if they permanently ban somebody without giving them a notice and opportunity to be heard, then the court will look at that. So those are the main areas that we see the habeas being used for it. Like I said, it's a little more expansive for tribes under the Indian Civil Rights Act, but your best bet is in the criminal setting.
Thank you. This is also including a habeas question. Any habeas cases coming from tribal defendants that stand out to you? Are you aware of any successful petitions?
Yeah. You sometimes see it where I've seen it in places where the tribe has its own habeas. So, you know, there was a situation where I didn't do it, a different attorney did it, but there was a case where the judge, the statute required bail. The judge had to set some sort of bail in a case. And then there was a case where the judge was really mad at the defendant, and the judge announced it was a no bail hold. And even though the code said that you had to give bail for that particular crime, and the defender was forced to do a habeas to the tribal court of appeals, they moved really quickly. It got in front of them. They convened a panel really fast, looked at it, and within a day or two had issued a writ and had the person released. Happened to me as a judge at Tulalip. That was me getting the code wrong. I did a no bail hold, passed arraignment on a domestic violence charge, because there is often you're allowed to do a no bail hold in certain cases. In domestic violence ones, you often will see a no bail. The judge can issue, that doesn't mean the judge can't issue a bail, but sometimes the judge did. And I had a really bad domestic violence case in front of me, and I just misremembered the code and thought I could do it after arraignment. It allowed me to do a hold up until arraignment, I think, and then after arraignment, it did it. I had, in my defense, I would have, if the attorney went and did a whole writ to the Court of Appeals, when they could have just done a motion to reconsider and point out that I got the law wrong, and then I would have put my tail between my legs and I would release the person. But they went all the way up to a writ to the Court of Appeals, and Court of Appeals kicked it. So those are the two instances that I've seen it happen.
Thank you. Can you tell us more about this question? Can you tell us more about banishment? Do you have any examples of tribes using banishment?
Oh, there's lots of examples of tribes using banishment. They'll call it banishment or they'll call it exclusion. That's one of the areas where tribes have a lot of authority, is the ability to remove somebody that's from the reservation. This power to exclude has been something that the federal courts have talked about for a long time as being almost like a law and order basis for tribal ability to do certain things. So this ability to exclude, you see it in a lot of treaties where the treaties recognize the ability of the tribe to exclude bad men from the reservation. So it's this really long-standing tradition amongst tribes to be able to banish and to be able to exclude somebody from the reservation. We see it now in a much more modern way with tribes, in that they'll have exclusion statutes or banishment statute that sets out what is a eligible act that could result in someone being banished. A lot of places it's sort of extreme things like conviction for like a sexual assault crime, rape, crimes against children. You'll see them often for cases where someone has been convicted of sale of drugs on the reservation, manufacturing or delivery of drugs on the reservation. You'll see a lot of exclusion or banishment codes related to that. It's usually a civil process. Sometimes it's not in front of the court. Often you'll find it that it's in front of the tribal council, and the council does the petition The attorneys will present it to the tribal council, and the tribal council will give somebody a hearing, and then the tribal council will decide on whether or not to banish. Some have a tribal court process. At Tulalip, where I was, the tribal council did the banishment, but the tribal court had jurisdiction to hear deferrals, because they had a process to where they could exclude somebody but then offer them a deferral. Usually if it was somebody who was selling drugs on the reservation, usually a tribal member, they would exclude their own members from the reservation for engaging in that activity, but they would often offer them a deferral, and essentially they would go into a very strict probation program that they'd have to get a chemical dependency assessment, follow all treatment recommendations, don't commit any new crimes. And if they did that for some period of time, like a year or 2 years, I can't remember, I think it varied from diversion to diversion, then the exclusion would be dismissed. And then the court would oversee compliance. So essentially the tribal attorney would come in and go over, the person had been doing their UAs, if the person had been doing their groups, if, no new crimes for this review period, and then the court would continue the diversion and eventually enter a closure of it. So it's a very common thing. You'll find that in a lot of tribal codes, some sort of process for diversion or for exclusion or banishment.
Thank you. That was all of our questions.
Okay. Well, in that case, thank you. And this webinar and other materials that are being developed under the Tribal Legal Advocacy Training Series, you'll be able to find those at NAICJA.org. Thank you for having me.
Yes, thank you so much, Ron. We really appreciate your presentation on ICRA. Like we said, if any viewers have questions, you can email info@naija.org. And we will have the rest of the Tribal Legal Advocacy Training Series online. We'll also share links on our social media, Facebook and Instagram. Thank you so much for joining us.